Mississippi is one of the most landlord-friendly states in the country when it comes to rent increases, and the regulatory framework here is about as minimal as it gets. If you manage rental property in Mississippi, you have virtually complete freedom to set and adjust your pricing, consistent with the state's overall hands-off approach to landlord-tenant regulation that we've discussed in our other Mississippi videos. As we've covered previously, Mississippi does not have a comprehensive residential landlord-tenant act. The landlord-tenant relationship is governed by a combination of Mississippi Code Title 89, Chapter 8, common law principles, and the terms of the lease agreement. This light statutory framework extends fully to rent increases. There is no state regulation of rental pricing whatsoever. Mississippi does not have rent control or rent stabilization of any kind. There is no state statute that caps rent increases, limits the frequency of increases, or requires any government notification or approval before a rent change takes effect. Mississippi's political and regulatory environment is firmly pro-property rights, and rent control has never been part of the state's legislative conversation. Mississippi has not enacted a specific preemption statute prohibiting local rent control. But this is entirely unnecessary because no Mississippi municipality has ever enacted or considered local rent restrictions. Jackson, Gulfport, Biloxi, Hattiesburg, Tupelo, and every other Mississippi community operate under the same market-based framework. Given the state's political climate and relatively affordable housing market, local rent control is not a realistic possibility. For month-to-month tenancies, the landlord must provide advance written notice before a rent increase takes effect. Because Mississippi doesn't have a specific statutory provision addressing rent increase notice periods, the general rule is that the landlord must provide notice equal to one rental period. Typically 1 full month's notice for a monthly tenancy. So if rent is due on the 1st and you want the increase to take effect on May 1st, you should deliver written notice by April 1st at the latest. The notice should be in writing and should clearly state the current rent, the new rent amount, and the effective date. While Mississippi doesn't mandate a specific statutory form, putting the notice in writing is essential for documentation purposes. In a state where the statute provides minimal guidance, your written records become your primary evidence if a dispute arises. Deliver the notice by a method that creates a verifiable record: personal delivery with acknowledgement, certified mail, or another documented method. For fixed-term leases, the rent is locked in for the duration of the lease term, unless the lease includes a provision allowing mid-term increases. Common mid-term adjustment provisions include escalation clauses, provisions tied to property tax changes, and CPI-based formulas. Without such a provision, the landlord must wait until the lease expires to negotiate a new rent amount as part of a renewal or new lease. When a fixed-term lease approaches expiration, the landlord should communicate the proposed new rent as early as possible. Mississippi doesn't prescribe a specific notice period for rent increases at lease renewal, because the increase is part of a new contractual arrangement, but giving the tenant adequate time to evaluate the new terms is good practice. If the tenant doesn't agree to the new rate, the lease expires at its natural end. If the tenant stays and the landlord accepts rent, the tenancy converts to a month-to-month arrangement, subject to the 1-month notice requirement for future changes. For week-to-week tenancies, the notice period for rent changes follows the 1 rental period rule: 7 days notice before the end of the weekly term. Now let's cover the restrictions that apply even in this permissive environment, because having no rent cap doesn't mean there are zero boundaries. Rent increases cannot be retaliatory. Mississippi doesn't have a detailed anti-retaliation statute with specific presumption periods and enumerated protected activities the way many states do. However, Courts recognize the common law principle that a landlord cannot use a rent increase as punishment for a tenant exercising their legal rights. If a tenant reports a health or safety violation to a government agency, makes a good faith habitability complaint, or exercises any other legal right, and the landlord responds with a dramatic rent increase, the tenant may have grounds to challenge it. The practical reality in Mississippi is that retaliation claims are harder for tenants to prove than in states with strong statutory presumptions. Without an automatic presumption of retaliation based on timing, the tenant must demonstrate through circumstantial evidence that the increase was motivated by the tenant's protected activity rather than by legitimate business factors. This means that while the legal risk of a retaliation claim is lower in Mississippi than in more regulated states, it's not zero, particularly when the timing and magnitude of an increase make the retaliatory motive obvious. For landlords, documentation and consistency remain the best protection. Keep records of market data, operating cost changes, and any property improvements that support your pricing decisions. Apply increases uniformly across comparable units. And avoid any increase that could reasonably be perceived as punishment for a tenant exercising their rights. Rent increases also cannot be discriminatory. Under the Federal Fair Housing Act and Mississippi's own fair housing provisions, landlords cannot raise rent based on a tenant's race, color, religion, national origin, sex, disability, or familial status. Mississippi's fair housing protections align closely with the Federal Fair Housing Act and are enforced through both federal and state channels. A discriminatory rent increase can be established through evidence of disparate treatment, raising rent for tenants of one racial or ethnic group while keeping rates stable for comparable tenants of a different background, implementing larger increases for families with children, or targeting tenants with disabilities. The pattern of conduct creates the evidentiary basis for a complaint, even without direct evidence of discriminatory intent. Mississippi also has general fraud and misrepresentation principles that could apply to egregious conduct involving rent increases. A landlord who fabricates cost increases or makes false representations about the reason for a rent increase could face legal consequences under common law fraud principles. From a practical standpoint, Mississippi's rental market is one of the most affordable in the country, and the dynamics vary significantly across the state. Jackson, the state capital and largest city, has the most active rental market in the state. Jackson's economy is driven by state government, healthcare, including the University of Mississippi Medical Center, and regional commerce. The city has experienced some population decline in recent years, and the rental market reflects a range of conditions. Some areas of Jackson, particularly the Belhaven, Fondren, and Northeast Jackson neighborhoods, have strong demand and support regular rent increases. Other areas face higher vacancy rates and more limited pricing power. The Jackson metro area, including Madison, Brandon, Ridgeland, and Flowood, has seen growth in the suburbs even as the city proper has faced challenges. Madison and Ridgeland in particular have attracted families and professionals seeking quality schools and amenities, and the rental markets in these communities are relatively strong. The Gulf Coast, including Gulfport, Biloxi, and Ocean Springs, has a rental market shaped by the military, tourism, and the gaming industry. Keesler Air Force Base in Biloxi and the Naval Construction Battalion Center in Gulfport brings significant military rental demand. Military tenants' housing budgets are tied to BAH rates, and landlords near these installations should monitor annual BAH adjustments when planning increases. The gaming industry provides additional employment and rental demand, though it can be sensitive to economic cycles. The Gulf Coast was also profoundly affected by Hurricane Katrina in 2005, and the rebuilding process reshaped the housing market. More recently, Hurricane Ida and other storms have reinforced the region's vulnerability to natural disasters. Landlords in coastal Mississippi need to factor storm risk and potential market disruptions into their long-term planning. Hattiesburg, home to the University of Southern Mississippi, has a student-influenced rental market, where demand follows the academic calendar. The broader Hattiesburg market benefits from healthcare, Camp Shelby, one of the largest National Guard training installations in the country, and regional commerce. Oxford, home to the University of Mississippi, has a particularly tight rental market, driven by the university. Ole Miss enrollment growth and the town's growing reputation as a desirable small city destination have pushed rents upward. Landlords in Oxford generally have strong pricing power, particularly for properties near campus. Starkville, home to Mississippi State University, has a similar student-driven dynamic. Rent adjustments in the student housing market typically occur at the beginning of each academic year. Tupelo, Meridian, Columbus, and other mid-sized Mississippi cities have rental markets influenced by local employers and regional economic conditions. These markets are generally affordable, with moderate pricing power for landlords. Rural Mississippi has the softest rental markets in the state. In many smaller communities, particularly in the Delta region, population decline, limited economic opportunities, and low incomes constrain rental demand and pricing power. Landlords in these areas need to be conservative about increases and focus on maintaining occupancy. One best practice for Mississippi landlords, because the state's legal framework is minimal, your lease agreement is your most important tool for managing rent increases. Include clear language about how rent adjustments will be handled at renewal, what notice will be provided, and what factors may influence the new rate. A well-drafted lease that addresses rent increases explicitly gives both parties certainty and reduces the potential for disputes. In a state where the statute provides virtually no guidance on rent increase procedures, the lease fills in all the gaps. Another best practice: consider the affordability context of your market when setting increases. Mississippi has one of the lowest median household incomes in the country, and many tenants are living close to their financial limits. A rent increase that would be easily absorbed in a high-income market like Charlotte or Nashville may be genuinely burdensome for a Mississippi tenant earning substantially less. This doesn't mean you can't raise rent. It means you should be realistic about what the market can bear and what your tenants can afford. An increase that pushes a good tenant out and leaves you with a vacant unit costs more than the revenue the increase would have generated. For landlords near military installations, understanding the BAH rate structure is essential. BAH rates are adjusted annually and vary by rank, dependency status, and location. Pricing your units competitively relative to the BAH rate for your area ensures that your property remains attractive to military tenants. The military population represents a reliable and financially stable tenant base. Losing those tenants by pricing above the allowance is a missed opportunity. Mississippi's hurricane risk creates an additional consideration for coastal landlords. Major storms can disrupt the rental market, damage properties, and temporarily reduce demand. Landlords in hurricane-prone areas should maintain adequate insurance coverage, build financial reserves to cover potential income interruptions, and have a plan for communicating with tenants before and after storms. Implementing a large rent increase immediately before or after a hurricane can be both practically counterproductive and reputationally damaging. Mississippi requires landlords to return the security deposit within 45 days of the tenant vacating. While this doesn't directly regulate rent increases, landlords should understand that increasing rent doesn't automatically entitle them to collect additional deposit from an existing tenant without a new agreement. Any change to the deposit amount would need to be negotiated as part of a lease renewal or amendment. For Mississippi landlords who participate in the Housing Choice Voucher Program, rent increases must be approved by the local housing authority. The authority evaluates whether the proposed rent is reasonable by comparing it to comparable unassisted units. Submit increase requests well in advance of the desired effective date. F.